To Senator Lankin.
Thank you very much for appearing, and thank you for the opportunity to participate. I'm not a member of this committee, but I'm engaged in this bill, so I'm here. I would like to say how much I appreciate your recommendation about sentence ranges reflecting the actual reality. I'm horrified that we could think of 14 years, the same maximum penalty that's for murderers and rapists, and it's just beyond comprehension for me, not with respect to trafficking and other things, but with respect to possession. I want to ask you specifically about the asymmetrical provisions, and I finally understood what everybody's been saying about this. It's taken me a couple of days to work my mind through it, but the solution, I've heard a couple of comments about just simply decriminalize under 30 grams, and for people under the age of majority, however that's set in provinces, or the legal age, however that is being set in different provinces, those people could be under a provincial ticketing regime, and I agree with that completely. Could the provinces put in place a regime that has differential fines or restorative or whatever provisions for under 5 grams and between 5 and 30 grams before it gets to criminalization? Would they have the capacity to do that? And if so, what amendments to this legislation, you don't have to write them today, but can you send us some potential amendments to the legislation that would address that issue?
Or just
let me start with the Criminal Lawyers Association. If others want to jump in,
okay, that's fine.
Okay?
All right.
Well, in dealing with easy division of powers topics, I was hoping you would start with the Canadian Bar Association.
Yeah, exactly.
Certainly there is room for the provinces to engage in that sort of legislation, and this was a topic of much discussion at the Legal and Constitutional Affairs Committee, because it is a very tricky issue when you're looking at divisions of power and what can be done. Certainly the provinces can't come up with sort of de facto criminal rules because that's in the federal government's jurisdiction, but certainly if some space is left open, much like we do for tobacco and alcohol, provinces can have their own rules. Now, just a word of caution, because I don't think that is necessarily a cure-all, because you're left with sort of a patchwork across the country. Mm-hmm. I mean, with alcohol, we're dealing with that, right? But for marijuana especially, we have to remember that even a provincial ticket for simple possession of marijuana can have some collateral consequences, like crossing the border, because of how serious it's treated. But certainly I think that approach would be much more beneficial than having it in the criminal code.
Okay, now the bar.
Yes, I think there's certainly plenty of constitutional room for a province to have a strata system. If, for example, the federal government said that everything under 30 grams is lawful and it will be treated as a health issue, as a social justice issue, as a youth issue, then the province would be able to impose a health regime with variations for that. I don't see any constitutional difficulty with that.
Monsieur Levesque.
Pour la barreau du Québec, non.
The Quebec Bar doesn't see a problem either, for example. Let's say that the 5-gram limit is no longer there and we move to 30 grams. We could imagine that a province might say, okay, we'll have a strata system, first offense, such and such, etc. It would be perfectly legitimate to do this. And we'd have to fall in with the parameters set out in the Constitution, but we could even use Section 7 of the Youth Justice Act. We could refer back to it to some extent, saying we'll avoid criminalization when there's a program in place. The province could say, I'll develop a program for everything over and above 30 grams, but below 30 grams, I'll view it with administrative sanctions, penalties, like with road safety and alcohol.
And finally, Senator McCallum.
Thank you. My question is, thank you for your presentations. I was really very glad to hear what you said, because I've been concerned about this law and how it applies to First Nations. And I had with two of the committees, the Aboriginal Committee and the Law, I had asked them a question about First Nations and their ability, that Section 35 of the Constitution gives them the right to make their own bylaws. So when I asked a question with the Legal Committee, I asked them if the province, he said if the province has a law that goes against federal law will supersede. And I said, okay, then you put First Nations into the mix, because First Nations issues are very unique with this bill. And I said, if they decide to go against both laws, who's going to prosecute those individuals? Because right now they've been made to believe that their bylaws will stand. I was at the special committee for special assembly for chiefs yesterday, and the chiefs were telling the other chiefs, start making your own laws. And I've heard this before at other chiefs' assemblies. Start making your own laws, and if we have to, we'll take it to court. So at some point, this issue will come to a head, and I believe it's unfair that where First Nations leadership has been put, because they're assuming they have authority over their land, and listening to all this, it doesn't seem that that's right. And then the other concern I had was that I believe this is a discriminatory law, and I'm wondering if you can speak to that.
Okay, we'll get all three of you responding, all three organizations, but briefly, please, because we're running over time.
I think very briefly, the submissions that we have made with respect to sort of marginalized and racialized groups apply with equal force to First Nations. There are some other additional considerations that the committee may want to think about. For example, the impact that this law might have on remote communities. For example, paying your fine within 30 days to avoid sealing your record may be more difficult if you live in a remote community, and access to legal sources of marijuana may be different if you live in remote communities. That may lead to more harsh criminalization. So I think all of those aspects can be troubling and can have an impact on First Nations. With respect to your first question, it's a division of powers question that I think is beyond our organization's scope to address, but it is certainly something that probably hasn't received enough consideration.
I'll deal with the division of powers issue, if I may. It's not at all clear that First Nations would have the authority to make such laws. Dominion paramountcy applies where, for example, a provincial law and a federal law clash and they cannot be reconciled. Then the federal law will take precedence. If the two laws can be reconciled, then there are areas of coexistent jurisdiction. And if a First Nations law could coexist with a federal statute, then they will probably be able to do that. But the issue of paramountcy is a fairly tricky one. And you also have to look at, actually, the possession of cannabis is actually a law under the Peace, Order, and Good Government section since the Supreme Court's decision in Hauser in the 1970s, not actually criminal law, which gives the federal authorities the power to prosecute. So that the federal government would continues to prosecute, and there can be delegations to the provinces, but generally drug offenses are all prosecuted by the federal government, and they would have the power to do that and continue to have the power to do that. So you're getting into an extremely tricky area, and I'm not sure that First Nations would benefit from it.
Monsieur Levesque.
Rapidement, le barreau peut
The Barreau can't really speak to this, the question of the division of powers, because in essence, we're uncertain. It depends on several factors, the judge, the circumstances of the case itself, and court judges in Canada also tend to interpret the act in such a way as to avoid a conflict. If there is a conflict, they'll give precedence to the federal level. Would that be the case here? It's very uncertain, so we won't speak to that. That being said, I can tell you, and I agree, that this can have immense consequences for Aboriginal communities, but social workers, defense lawyers, judges, and it's set out in the criminal code, know that we must not and do not deal with Aboriginal offenders in the same way as the rest of the population for historical, sociological reasons as well. And it's especially the case on reserves. So if the act remained unchanged, you could think or could say that the reaction of the interveners in the justice system would deal with Aboriginal people differently, taking into account the fact that they're already vulnerable and overrepresented within the system.
To all three organizations, all five people that have been part of this panel, and we appreciate your perspectives on this very much, and I think you've had quite an impact on our committee. And if the committee wants more, 10:30 tomorrow morning, we have two more panels tomorrow morning, and we also are going to deal with the social finance. Senator Ahmed Var, we're going to deal with social finance tomorrow as well as in camera, a draft report on that. So with that, I declare the meeting